The Office of the Registrar is created in terms of the LRA, is an office of the regulator. Trade unions, employer organizations, bargaining councils, they report to the Office of the Registrar regarding their compliance with the Constitution, their compliance with the LRA. A notice of intention is to basically inform the public and the union the intention of the Office of the Registrar, because through our regular monitoring, which is done on a yearly basis, that we will communicate with the union, for example, regarding their compliance, for example, submitting audits, membership numbers, information of their leadership, to name but a few, that they must, in terms of the LRA, are supposed to submit to our office, that they fail to submit as required by the LRA. So the registrar does not have unlimited powers. The cancellation is one of the processes that the office undertakes to cancel the registration of the union. It's more of a wake-up call for the union to inform them of the intention of the Office of the Registrar, that if they don't submit their compliance issues, then it might lead to the cancellation of such a trade union. Failure to submit their audits, which is a big issue for us, because unions, they receive membership fees, so they must account for such membership fees. So the law requires that they must audit, and after auditing, they must submit to the Office of the Registrar. And in many times you find that the unions, they don't audit, and we are left with no choice but to cancel or to publish an intention, which will at the later stage lead to cancellation if they don't remedy the situation. That's why there is an intention is provided in the LRA. We will give an intention that we intend to cancel the registration of the trade union. Any interested party, a member of the union specifically, they have an opportunity to submit representations in writing. That's what the Act is saying. So then after receiving those representations, the office will analyze that and make a decision whether to proceed to cancel or not to cancel. So they definitely have an opportunity, which is 60 days, to submit those representations. It means that if the union is cancelled, you won't be able to be represented by such a union, because such union will become unregistered. Because registration comes with responsibilities, and is when you are registered that such a union enjoys organizational rights, like engaging employers, which is their right as well. They will collect stop order fees through the stop payroll of the company. So if as a worker your union is still registered, it means that when you are in trouble, such a union might not be able to assist you because they will not be registered. A member of the public, a member of the union, they are welcome to approach our office to find out if their union is compliant. They have a right to ask for any information from our office regarding their union, because in many cases you find that they approach their union to find out what is going on, and then you find that the union does not give them the information. So the Office of the Regulator, which is the Office of the Registrar, is there to be able to provide information to them as members of the union. And members of the public, there's certain information that they can be able to get from our office. We regularly get inquiries from employers, from members of the public, to find out whether the union is registered, is it in good standing, is it submitting its audits before they engage in organizational matters. So then our office will be able to respond to such questions or inquiries. The first thing, they must comply with what the LRA is saying, keep proper records, audit, comply with their constitution, have elections that they are supposed to be having regularly in terms of their constitution, then there won't be an intention to cancel, or they won't find themselves in hot water with the office of the registrar. So they are definitely, and where they don't understand or they seek guidance, our office is always available to offer any assistance regarding whatever questions that they might have that they are not sure of. The message that I can leave the public is that workers, they must exercise their constitutional right by forming a union of their choice or joining a union of their choice, and so that they can be protected when they are facing any challenges with an employer, for example. And they should not be bystanders. They must be actively involved in the affairs of the organization to make sure that things are running smoothly. Because if they are not, they are bystanders, then you will find that things are happening without their knowledge. And if they are not sure of something, or they're not getting any answer from their union, our office is always open to try and advise them.